Good evening. Good morning. Whatever. I'm tired. I'm drinking a caffeinated beverage. Stupid Australians with their good evenings and lates. Oh, piss off. Here we go. Merb is going to defend Earl. No, Merb is going to defend what little justice we have in our legal system. I've said before many times that we have a legal system, not a justice system. And I would like to see all the justice wrung out of the legal system that I can. And I would like to see that justice wrung out for not only people like Earl, but for everybody, including people who are actually innocent. I've always maintained that Earl is guilty. It's my belief he's guilty. But I want to see him get a fair trial. This is live, Pat. I want to see him get a fair trial. And I want to see him get convicted in a way that people who are on his side, who think he's innocent, can't point at someone like Dougie to say, oh, it was biased. Earl was actually innocent. And it's all because Dougie got in the way and influenced the jury that now all of a sudden the conviction is granted or found, whatever. I'm really tired. So I want a fair trial, and I want a fair trial for the victim, and I want to make sure that nothing gets overturned on appeal, because you got to remember that like Earl does have options. He has a lot of options. If he doesn't get this new trial, he can appeal it. He can appeal the motion for a new trial, and or the denial of the motion for a new trial, and drag this out. And it leaves. It's Doug Ripley, Maddie W. It's Doug Ripley. It's the crayon eater himself, the crayon bandit. It leaves a lot of. You got to remember the victim. The victim is out there. She's placed herself on the line. She has testified against her father, and she's alienated her family, and she is having to live on the edge of whether or not Earl is going to get back out into society and on a technicality or something like that. So I want closure for her. So with all of that preliminary aside, let's get into the motion for a new trial. So Earl David Warden, defendant, through his attorney Brian W. Garris, files this motion for new trial. That is supposed to be a superscript 1. In conjunction with this filing, Mr. Warden also files his exhibits to motion for new trial. This filing was submitted separately so that the court could place the exhibits under seal or as a sensitive data document should the court deem it appropriate to do so. Those exhibits are incorporated by reference for all purposes. Now, I do not have those exhibits. However, we should be able to deduce the basic concepts of those exhibits. Now, what we're looking for is we're looking for Earl to present a case where if the affidavits are true, he doesn't have to prove they are true. He has to show the court that if the affidavits are true, then there was the smell of taint. It's reasonable that there was some taint to the trial. He doesn't have to prove it beyond a shadow of doubt. I mean, it's a very low bar, because even though we have a legal system and not a justice system, the legal system is concerned with the appearance of justice. So that's why judges are often required to recuse themselves to say I can't try this case if there is an appearance of a conflict, not if there's a conflict, if there's an appearance of a conflict, because we don't want people to think that the system is biased. Now, the system is broken. I mean, it's completely imperfect. Don't get me wrong, but we want to avoid the appearance of a faulty system. So it's a fairly low bar that Earl has to hurdle, and it doesn't mean he's innocent. It means that he might get a new trial. You got one other thing you have to remember. Earl can be a piece of shit and Dougie can be a piece of shit at the same time. Both Earl and Dougie can be pieces of shit. It's not a either or. It's not a if Dougie's a good guy, Earl's a bad guy, and if Earl's a good guy, Dougie's a bad guy. They can both be pieces of shit. I just want to be very clear about that. So Earl has a fairly low bar to prove. Look at my previous video on it to get an idea of how easy it is and how preferential it is to have a new trial. So in the above style cause and moves this court pursuant to Rule 21 of the Texas Rules of Appellate Procedure to order that a new trial to be held in this case. And Rule 21, we went over some of the bases for that. Number one, the state's flagrant interjection of racial and religious animus and stereotyping into the trial in violation of the First and 14th Amendments to the U.S. Constitution, Rule 404 of the Texas Rules of Evidence, and Article 38.37 of the Texas Code of Criminal Procedure. Since my chat was talking about Chile so much earlier, Chile likes to think there are 5 rights guaranteed in the First Amendment. There are actually 6. There's the Establishment Clause. There's the Free Exercise Clause. There is the freedom of assembly, the freedom of speech, the freedom of the press, and the right to petition the government for redress of grievances. That is 6 rights. So that idiot saying 5, Jesus, just read the First Amendment, dude. Read it. 14th Amendment would be the Equal Protection Clause is what they're referencing. Rule 404 of the Texas Rules of Evidence, if that's anything like the federal rules of evidence, then that's going to be character evidence for criminal matters. You can't show character to prove that someone is more likely to have committed a crime. And Article 38.37 of the Texas Code of Criminal Procedure, I'm not familiar with it. I'm assuming they're going to cover it down here somewhere. I haven't read this, so you'll have to forgive me. I have looked at this first page, obviously. Number 2, repeated outside influences on the jury and jury misconduct, including an attendee perceived to be associated with Mr. Warden, following jurors to their cars. Well, that's phenomenal. Whew. I wonder what idiot did that. Communications and attempts. It's not just the communications, it's the attempts to communicate to jurors, including individuals with Mr. Warden, shouting that other attendees were supporting a rapist and a sex offender within earshot of the jury. I mean, if true, just imagine this. If true, if there were people there against Earl shouting that the other attendees were supporting a rapist and a sex offender, and they were doing that within earshot of the jury, how could that not be prejudicial to Earl? How could that not? You know, I'm not saying that Earl's not a rapist. He's a convicted rapist. I'm not saying that he's not a sex offender. He is a convicted sex offender. But what he was on trial for was whether or not he assaulted his daughter. And just because Earl's bad doesn't mean that the people who are protesting against him by ruining the fairness of the trial, it doesn't make them good. And the court impermissibly commenting on the weight of the evidence in that the jury heard about, quote, 25 years of this dysfunctional family in 2 days. I'm not sure that is terribly prejudicial. A dysfunctional family doesn't mean that he molested his daughter. And repeatedly emphasizing to the jury that there was a lot of crazy stuff on the internet about Mr. Warden if they were to Google him. And that's a little more, that one of the things I was concerned about was the jury Googling Mr. Warden. And if the court is telling the jury there's a bunch of crazy stuff out there, that might not be so awesome. These outside influences violated Mr. Warden's right to a jury trial and his right to due process under the 6th and 14th Amendments to the United States Constitution. The 6th Amendment is your right to a jury trial. If you are facing the potential of, I think it's more than 6 months in jail, it's kind of nebulous. If you're facing felony jail time, definitely you are entitled to a jury trial. Number 3, the state's presentation of false and misleading evidence before the jury that Mr. Warden was a racist and a Mormon. I don't know why. Why is all this Mormon stuff coming up? Until this trial, I never heard that Warden was a Mormon. I never heard that until this trial. Then all of a sudden, with this trial, I had one guy blasting my Discord about Mormons and how Mormon women are stupid or something. It was pretty offensive, but I mean, free speech. And number 4, ineffective assistance of trial counsel. Okay, that makes sense. That makes sense why he has a new attorney. I don't know. Oh, well, I guess I should read to figure out why it was ineffective assistance of trial counsel. In failing to object to the prosecutor's injections of racial animus into the trial. I wonder what racisms? Because like the first time I ever heard of Earl, he was cop watching with the Bateau Sai. Who Philip Turner is black, so and I thought that Earl and what's his name, Fred, News Now Oklahoma, I think his name is Fred or something like that, who's also black, so I'm not sure what's going on there. And failure to object to the prosecutor's closing arguments that Mr. Warden was a racist and a Mormon. Oh, yeah. After a procedural and factual background, these issues are discussed and presented in turn. So we have a background. Number 2, it should be noted that at the date of the filing of this motion for a new trial, Mr. Warden does not yet have access to a prepared copy of the trial transcript. It should be indicated by the court reporter that it will take some time to have the transcript prepared and that it could not be prepared in advance of the deadline for this filing. He had 30 days from the date of conviction to file, and so he did so. Just making sure for the record I'm not Mormon or black. Well, good for you. Only 2 things come out of Oklahoma. All right. Mr. Warden was charged by indictment with the offense of sexual assault of a child under 17 years of age. See Exhibit A, indictment. I don't have any of the exhibits, so I can't show them to you. So I apologize. The indictment returned on July 2nd, 2019, alleged an offense date of January 1, 1997. After litigating numerous pretrial issues, Mr. Warden entered a plea of not guilty, and the case proceeded to a jury trial in December of 2022. Mr. Warden was represented by trial counsel Jonathan Landers and Kobe Dubois. See generally Exhibit 2, Affidavit of Defense Counsel Landers. The trial was held before the emergency relief docket of the 228th District Court, was presided over by Judge Jim Anderson, and was held in the old Harris County Family Law Center at 1115 Congress Street, Houston, Texas, 77002. Mr. Warden is a well-known police accountability activist and publisher. Now, whether or not you disagree with that, remember this is from Earl's perspective, and he's not going to include things that are harmful to his motion. The state will have the opportunity to oppose his motion. I don't know if they've done so yet. Last time I checked, they hadn't done so, but they will have an opportunity to put their spin on things. This is Earl's best foot forward. With a large fan base that includes a large number of internet followers. See Exhibit 2, Landers Affidavit at 1-2, and Exhibit 6, Pulliam Affidavit at 1-2. Mr. Warden's activism has also made him a target of a large anti-fan base that includes individuals Teresa Richard and Douglas the Crayon Eater Ripley, the Crayon Bandit, both of whom attended the trial. Mr. Warden's celebrity within that activism community made the trial of particular interest to his fans, his anti-fans, and those generally interested in police accountability issues. See also Exhibit 5, the Gray Affidavit at 1. He didn't plead guilty. He did not plea. Okay. And yes. All right. So Mr. Warden's activism has also led to the instant charges being filed. again, I disagree with this statement, but this is Earl putting his best foot forward. I think that his activism led to the police rediscovering a case file that was not closed and looking into it and finding out that it had been improperly forgotten about. So, you know, I think, I think, uh, his daughter's uh, statements that Earl had assaulted her led to the instant charges being filed. Those were the legal and proximate cause. Um, the fact that they were forgotten on a shelf for some time is bad. And then they started looking into Warden and they found that file. That's good because we can get justice. And justice is something to be striven for. And it only comes with fair trials, or it only has the possibility of coming with a fair trial. Mr. Warden has been publishing about a security head. Mr. Warden had been publishing about a security head at the Shell refinery in Deer Park, which led directly to the Deer Park Police Department beginning an investigation into Mr. Warden. The Deer Park Police Department initially tried to have Mr. Warden charged with a sexual assault against another person, not the complainant in the instant case, but was unsuccessful as the Harris County District Attorney's Office refused to accept the charges. And they are looking at the Landers affidavit for all of these things. I'm not sure how useful that is. I mean, Mr. Warden allegedly had raped multiple victims when he was charged for the rape of a single individual back in, what was it, the 80s? And he was convicted of that one rape. And because of a motion in limine, I don't understand this. The prosecution decided to only go with the one rape charge. And I don't understand why they chose to do it. I think maybe their evidence for the other alleged rape victims was poor. So they decided to just go with the one, and then they wanted to introduce the other alleged rape victims in the sentencing phase to get a longer sentence. The defense counsel, I guess, smelled that coming, and they filed a motion to suppress any evidence of any other rape allegations that weren't being charged. And the court granted that motion. And so the other alleged rape victims, they were not given the opportunity at the sentencing phase to discuss their interactions with Mr. Warden, their alleged interactions. So there are other women out there who have alleged that Mr. Warden has engaged in inappropriate sexual conduct with them, and they have not had charges filed against him due to whatever reason, failures with the district attorney's office. And again, we have a legal system, not a justice system. So, don't cry at me about that. I didn't make it. The investigation then moved to the complainant in this case, who had not made any contemporaneous outcries of sexual assault. That's kind of a weak argument. That's a super weak argument. She's not saying today that she was being sexually assaulted. So, like, what? She said in the past that she was. That's for darn sure. And it didn't go away. So how about that? As discussed in defense counsel Landers' affidavit, the evidence of sexual assault was scant. It was apparently enough to convict him. There was no contemporaneous outcries, no physical evidence to corroborate the complainant's claims of sexual assault, and the allegation that Mr. Warden snuck into complainant's room each night for 2 years in a trailer house with 7 people without anyone ever noticing anything seemed impossible, except the other 2 daughters who were not allowed to testify. Well, I think only one was allowed to testify, but there were 2 daughters, in addition to the complainant in this case, who alleged that Earl engaged in inappropriate sexual conduct with them. So again, I'm not really feeling this particular argument, but again, this is Earl's best foot forward. Earl's appealing, not to me. No, he's not appealing. He's not appealing. Additionally, the defense heavily relied on the contention that the complainant's story lacked credibility, as the complainant's story changed not only prior to trial, but during her testimony before the jury. I did not hear her testimony before the jury, so that would be interesting to figure out. The complainant's claims were also contradicted by the other state and defense witnesses, including her sister. That's interesting. See Exhibit 9, juror notes. Oh, they got the juror notes, so that's good. These direct contradictions were made the subject of several juror notes during the deliberations. That is interesting. That is interesting. How many people were aware that there were contradictions between the testimony of the complainant and the testimony of the other daughters? I certainly was not aware of that. So that's something to think about. I mean, a lot of us are sitting out here only knowing information that we gathered outside of the trial, outside of what the defense and the prosecution were able to put forward. And that's how I came to the conclusion that Earl is probably guilty. But who knows? I mean, if there are these direct contradictions, maybe there's something there. Always keep an open mind. Always understand that you could be wrong. Now we have the state's injection of race and religion into the trial. During the complainant's testimony, the state presented highly prejudicial, inflammatory, unnoticed meaning that they didn't give notice to the defense. So during the complainant's testimony, the state presented highly prejudicial, inflammatory, and unnoticed bad act evidence that Mr. Warden refused to allow his wife to live at their trailer home because she became impregnated with a black child. See Exhibit 2, Lander's affidavit at 4, Exhibit 3, Dubois affidavit at 4 to 5. The state's emphasis was not on any fact that she was impregnated with another man's child, but specifically that the child was excluded because he was a black man's child, that the child was black. The state emphasized this point, which defense counsel Landers recognized has zero to do with any elements or issues involved in Mr. Warden's trial during its closing arguments. The prosecutor, herself a black woman, emphatically raised her voice and pointed at Mr. Warden during these remarks of her closing argument, asserting to the jury, which was comprised of at least 4 black members, that Mr. Warden was a racist because he would not raise a black child nor allow his wife to live with him while she was pregnant with a black child. See also Exhibit 4, the Hart affidavit. Well, that is, if true, that is certainly prejudicial. And apparently it's puppy playtime in here, which is awesome. So enjoy. But it has nothing to do, Earl's racism or lack thereof, his willingness to raise a black child or to allow his wife into the trailer if she was pregnant with a black child, has absolutely nothing to do with whether or not he sexually assaulted his white daughter. So prejudicial if true. And apparently the dogs have crunchy things to chew on right now, so enjoy that as well. This is going to be an ASMR session for you, so enjoy it. Defense counsel Landers recognizes that this claim against Mr. Warden had never been made prior to trial, i.e. it was unnoticed. So the state basically has to give the defense all of the evidence that they intend to introduce at trial. And if they fail to do that, that's a Brady violation. So I believe it was a Brady violation. Caught him off guard, and that he failed to object to this testimony, which would have been inadmissible. Yeah. If he had noticed that the state was intending to introduce that evidence, he probably would have filed a motion in limine to prevent the state from dropping that bombshell on the jury, because you can't unsay that. So the jury would have heard it, then he would have objected, and then so he probably would have done a motion in limine to exclude that had he known it. Assuming that he is in fact the second best attorney in Harris County. So assuming that. Defense counsel Landers recognizes the damage that was done by the state's presentation and the emphasis on their claim that Mr. Warden is racist and that this unnoticed bad act evidence was very harmful and cast Mr. Warden in troubling light. Yes, that is truly a bad thing to have. The state went even further, claiming that Mr. Warden was a Mormon and that he tried to make complainant convert to Mormonism so that he could marry her. That would be, I think in my mind, that would be more relevant because he was using it as a tool to get his daughter, who he allegedly was having inappropriate sexual relations with, to marry him. I think that is more relevant. Again, I would, if I was defense, I would definitely in limine motion to suppress that particular evidence or statement, but I could see there's a chance that the judge would allow that evidence in. The suggestion was made to the jury that it is acceptable in the Mormon Church to marry one's own children. During closing argument, the state was again pointing and yelling at Mr. Warden. Yelling. That would be interesting. That'd be interesting if the court was allowing the state to yell at the defendant. And claiming before the jury that he uses Mormonism to try to marry his daughter. And again, I apologize about the ASMR. Defense counsel Landers objected to the state's two asked questions about Mr. Warden being a Mormon during the trial. The court words are hard. The court sustained the first objection, but overruled the second objection. Trial counsel failed to object when the state argued the improperly admitted evidence during closing arguments. The state's presented attacks on race and religion were not only inflammatory, they were false and misleading. Mr. Warden is not a racist, nor has he ever been a Mormon, or a member of the Mormon Church. Mr. Warden is a longtime Baptist and even attended Baptist schools growing up. That's not really, I'm not a big religion guy, but it's not a glowing endorsement of the Baptist Church that that Earl was, a convicted rapist and at least 3-time felon, maybe 4-time felon, was a Baptist. Not a glowing endorsement. Outside influences on the jury, juror misconduct. And by the way, we have a star in here. We have Teresa Richard, who is in here. So congratulations, Teresa Richard, for getting named in here. As discussed above, several people actively against Mr. Warden attended the trial, including Teresa Richard and Douglas the Crayon Bandit Ripley. These individuals sat on the side of the split courtroom associated with being for the prosecution. Other attendees, including John Gray and Justin Pulliam, both reporting on the trial, sat on the side of the courtroom associated with being for Mr. Warden. The court, the bailiffs, the prosecutor, and defense counsel were actively concerned that attendees might try to influence the jury. I share their concern. I also was concerned. The defense brought up these concerns with the court on numerous occasions, including with the prior judges who presided over the pretrial settings. I would have, so there's competing interests here. There's the right to a fair trial, and Earl has a right to a fair trial. I mean, he has a right to a fair trial. That should not be argued. But there's also the right of the public to attend trial. You have a right of access. And the court has to weigh those two rights. Now, in court, especially at a criminal trial, the right of the defendant to have a fair trial outweighs the right of the people to access the court. First-year family law attorney teaches law to his 2 dogs. Would be worth 2.5 million views on the Dodo channel, brother. Yeah, my dogs aren't really paying attention to me. They have crunchy things that they're chewing on. So I can see why the court might make a decision to keep the courtroom open, but considering what was at stake, i.e. a man's freedom, which essentially for the rest of his active life until he's in his 80s, I would have preferred a closed trial. Now, that's just because I want justice done. I don't want I don't want anybody to be able to say that anything was hinky during this. Compounding these concerns, during trial, the jury was walked in and out of the courtroom through the same doors that were used by the general public to enter and exit, and the jury used the same elevators used by the public. These concerns came to fruition during voir dire, or voir dire, or however you want to pronounce it. I say voir dire. Defense counsel Dubois observed Mr. Ripley, the crayon bandit, speaking to a veneer member. This was brought to the attention of Judge Yates, who presided only over voir dire. Judge Yates told bailiff, who ejected Ripley from the courtroom. Mr. Ripley was allowed back into the courtroom during the subsequent trial days. Attorney Dubois observed Mr. Ripley would loiter in the hallways and near the elevators, which were within earshot of the jury room, and that he would frequently observe Mr. Ripley near jurors who were both coming and leaving during the breaks and after the trials. So this is what I was talking about. Like what if Dougie, as he stated, was only talking about horses and which crayons taste best? What if, if that's the case, great. But there's now, because of what he did, because he was so fucking stupid, and because of his past and all this other bullshit, because of that, now he has created the appearance of impropriety. And you can't take that back. No matter how much you want to defend Dougie, and I understand that Dougie has his little PK supporters that are running around, no matter how much you want to defend him, there is always going to be the appearance of impropriety. Red crayons are the best. Okay. I mean, everybody has their thing. I like the purple ones. So, and Dougie is an equal opportunity crayon eater. So he'll eat whatever you put in front of him. More troubling issues were observed. During a Tuesday break, John Gray observed Mr. Ripley and Miss Richard. During a Tuesday break, John Gray observed Mr. Ripley and Miss Richard were observed. Oh, that's a terrible sentence. So Mr. Ripley and Miss Richard were observed in the hallway by the elevator banks. They were in a heated discussion and argument with Jack Miller. Again, I don't think Jack Miller should have been there. And Miss Richard told both Mr. Gray and Miss Miller that they were supporting a rapist and a sex offender. This was within earshot of the jury and was loud enough to get the bailiff's attention, who came around the comer to the elevator area. I came around the comer. I'm sorry. I have the sense of humor of a 12-year-old. So the Crayola flute flavored box is tasty. Merb is a man of class and sophistication. He takes off the paper before indulging. Absolutely. Tara Sieber, the significant other of Mr. Warden's son, also attended the trial. Why can't they can't say like girlfriend or fiance or something like that? The significant other? That's a weird way of saying it. That's an odd way of saying it. I wonder why they chose that instead of saying girlfriend or fiance or wife or whatever. The significant other. The ex? I don't know. Miss Sieber was outside the courthouse smoking a cigarette as jury deliberations ended on the first day of trial and jurors exited the courthouse. According to Miss Sieber, she observed that she saw Miss Richard was outside initially on the sidewalk of Franklin Street nearest the courthouse, standing with an older gentleman. Miss Sieber looked away and saw that two female jurors were across the perpendicular San Jacinto Street. I'm going to say Jacinto. Jacinto? Jacinto? I'm going to say Jacinto. There we go. Miss Sieber states that as she looked back to her left, she observed that Miss Richard had crossed Franklin Street and was talking to two men she identified and believed were jurors. Miss Sieber observed that Miss Richard spoke to the two men, an older white male with her. By the way, the reason why I say Richard was because I used to say Miss Richard, but she corrected me, and it's Reeshard or something like that. So, Richard, an older white male with a beard and a younger, skinnier male for about a minute. Miss Sieber did not know what Miss Richard said to the two jurors, but observed her speaking to them from across the street. Again, That shows a lack of wisdom there. The appearance. See, they don't have to say that you said something that necessarily affected anything. All they have to do is show that there could have been something that reasonably affected the outcome of the trial, that tainted the jury pool. Oh, hold on a second. Somebody, Jacinto. Okay, it's Jacinto Street. My bad. And Hemming is saying Hemming was supposed to have been there, but he never actually went there. Jurors also reported that during the first day of jury deliberations, they were followed to their cars by Mr. Gray, who was carrying camera and recording equipment. So they were followed by Mr. Gray now. So this Mr. Gray, I believe, was on the on the defense side. That's what is that? Extra good citizen. Mr. Gray confirms that outside the courthouse, he encountered a group of individuals he knew were jurors, saw those jurors looking at him, and walked just a couple feet behind the group. Mr. Gray confirms he was carrying his camera equipment, which contains a cell phone attached to a gimbal and has lights and a microphone attached. Mr. Gray states that he walked with those jurors and even walked within their group until he realized he was walking in the wrong direction. Mr. Gray states that he then began to walk back to the courthouse where he encountered a second group of jurors that he recognized. Mr. Gray made eye contact with those jurors, walked through the second group, and then stated he proceeded to his car to go home. The jurors reported that they were being followed by Mr. Gray to the court. What a dumbass. When Mr. Gray came into the courtroom the following day, again carrying his camera equipment, he was confronted by Judge Anderson, who asked the bailiff, "Is this the guy messing with my jury?" The bailiff said that two jurors had confirmed that Mr. Gray was a person who had followed them. Judge Anderson ordered Mr. Gray out of the courtroom. Following the jury verdict, Judge Anderson recognized the impact that Mr. Gray, who the court and presumably others associated with being in support of Mr. Warden, had on the jury. So Gray stupidly walked with jurors, not realizing he was going the wrong direction. Right, buddy. And then they rightfully said, this guy's been following us, and they associated him with Warden because he'd been sitting on Warden's side, and now they're prejudiced against Warden. So congratulations, Mr. Gray. What a dumbass. Oh. And again, this is why I think the court should have been closed. It is recalled that Judge Anderson stated, Mr. Warden's friends didn't help him out too much, and or your friends haven't done you any favors with the jury, and or his friends had done him no favors with the jury, and that the jurors were scared. So the judge associated Gray with Warden, is what they're alleging. Judge Anderson indicated that Mr. Warden should think about dismissing his, quote, friends, end quote, from the courtroom because having them in the court could harm him if the jury decided punishment. The jury itself seemed to be greatly troubled by these issues, even going so far as to write a note to the court asking the court refrain from using names to refer to die jurors. Die jurors? Jim O'Donnell says, Merb, please don't forget that Earl himself pleaded on his channel and his son's channel for all these clowns to attend his trial. Classic case of be careful what you wish for. Yes, Earl's not smart. And Earl did a lot of things that a smart person wouldn't do. He also apparently molested his daughter. So anybody taking advice from Earl, I mean, just take it for what it's worth. Jury note 11 read, please refer to me as Foreman and not last name due to not wanting the audience to know last name. Congratulations, people. The trial court itself also served to be a source of outside influence during jury deliberations. At the end of the first day of deliberations, the jury indicated they were gridlocked at a 6-6 vote. Oh, I was wrong, though. At the end of the first day, they indicated they were gridlocked at a 6-6 vote. But I was wrong. I was wrong when I said it was 6-6 or 7-5 or whatever. I was wrong, guys. I was wrong. Apparently. The jury was brought back into the courtroom, and the court inquired as whether the jurors felt that additional deliberations would be beneficial. Defense counsel Landers recalls that 6 jurors explained they would not be changing their vote. Just before the jury was released for the day, the trial court told the jury that they had sat through 25 years of dysfunction of the Warden family, which had been distilled into 2 days of testimony for them, and they should evaluate their conscience. What the fuck does that mean? Why would a court tell them to evaluate their conscience? That's weird. That's weird. Well, things move too fast. Source: here is the record? Question mark. They said that they didn't have the trial transcript, Felipe. They did not have time to go there was not time to have the trial transcript made. So this is going to be made from just the affidavits, I'm assuming, of people who were there. I'm assuming that Earl was there and he would know what they said. He is a liar, but the court doesn't know that. I'm assuming that Landers and Dubois would have paid fairly close attention to what the jury would have come back with. And yes, I am always wrong because I am just a first-year family law attorney. So there you go. But evaluate their conscience. That's freaking weird. I don't know why the court would say that. That is very weird. The trial court also reminded the jury, as it had throughout the trial, that if they Googled about the case, there would be, quote, crazy stuff, end quote, out there. Yeah, that's bad because you're almost asking them to go Google it. If you didn't tell them about the crazy stuff out there, then they would be less inclined to Google it, I would assume. The repeated emphasis was not merely that the jury should not consult or read any outside sources, but rather focus the jurors on the information they would find if they were to do so in a way that seemed to create interest. So those are the basic allegations. Now we're going to get into the legal arguments. So this will be fun. Mr. Warden's conviction was the result of the state's injection of racial and religious animus and stereotyping into the trial, outside influences on the jury and juror misconduct, the state's use of false and misleading evidence, and the ineffective assistance of counsel. This false and misleading evidence, see, the jury is the one who gets to determine what weight and credibility to put to evidence. So I'm not sure that that's a good argument. I mean, I can understand why defense would throw that in there, but generally speaking, a court of appeals is not going to disturb findings of fact by a jury unless it is so egregious that no reasonable juror could have drawn the conclusion from the evidence. But if the jury decides to discount evidence, like if you have 2 people coming in, one person says Billy Bob did it, the other person says Billy Bob didn't do it. The jury can find either way. The jury can say Billy Bob did it because we believe the guy who said Billy Bob did it, and we don't believe the guy who said Billy Bob didn't do it. So, and ineffective assistance of trial counsel. These errors can only be cured by the granting of a new trial, and this court has the authority and obligation to grant a new trial under such circumstances. These issues are discussed and presented in turn. Number 1, the state's injection of racial and religious animus into the trial violated the First and 14th Amendments to the U.S. Constitution, Rule 404 of the Texas Rules of Evidence, and Article 38.37 of the Texas Rules of Evidence, and a new trial should be granted. Mr. Warden should be granted, as discussed in the background, Section Supra and Section 3, Mr. Warden's false and misleading evidence claim infra. The state's claims are false. Mr. Warden is not racist, and he's not a Mormon. I don't think he was convicted of being a racist, and I don't think he was convicted of being a Mormon. So I don't think it's the presentation of false and misleading evidence. I think it is the presentation of prejudicial evidence, improper evidence. not false and misleading, but improper and prejudicial evidence. Mr. Warden should be granted a new trial in this action because the state's injection of racial and religious animus into the trial, claiming he refused to associate and live with his wife, who was pregnant with a black child, and that he was a Mormon seeking to get the complainant to convert to Mormonism so he could marry her, violated his rights under the First and 14th Amendments to the U.S. Constitution, also violated Rule 404 and the Texas Rules of Evidence as they were unnoticed extraneous bad acts. In Dawson v. Delaware, the U.S. Supreme Court recognized the First and 14th Amendments to the United States Constitution generally precludes the use of an individual's associations and beliefs at trial. That's the Aryan case, Aryan Brotherhood. And I thought that was limited to sentencing, not trial. I didn't know that it was. Maybe I'm wrong. Where those associations and beliefs are not relevant to the issues in the case. Though Dawson was a case examining the use of defendant's gang membership, right of association during the punishment phase. The Texas Court of Criminal Appeals has recognized that Dawson extends to First Amendment. Okay, so Texas extended it to during the guilt-innocent phase of trial. Okay, all right, that makes sense. And he cites Davis versus State and ex parte Martinez. The premise underlying Dawson's holding is that the First Amendment, applicable to the states through the 14th Amendment, protects an individual's right to join groups and choose or not choose to associate with others. That's the freedom of association. The penalization of an individual based on these First Amendment protections, where the evidence is not relevant to the issues at trial, is nothing more than serving to penalize him for his abstract beliefs, and is employed simply because a jury could find these beliefs morally reprehensible. Now, I believe that if you can show that somehow the gang affiliation or the association to the bad group is relevant to the crime, like say for example, gang X has an initiation ritual where you have to kill a member of gang Y to become a member of gang X. Then the association with gang X might be relevant. You know, you're on trial for murdering a member of gang Y, and now you're a member of gang X. So that might be relevant. But just saying that, in the particular case in Dawson, it was a case where a guy had some sort of like a Aryan Brotherhood. I think it was Aryan Brotherhood, but it might have been like neo-Nazi or something like that. I don't remember exactly it was some white power organization. It was the Aryan Brotherhood. It was prison gang. Yeah, it was the Aryan Brotherhood. So he had a tattoo on him, and the prosecution was going to make him stipulate to it, I think. But anyway, the prosecution was able to use his affiliation with a white supremacist gang to enhance his sentence, and the Supreme Court said you can't do that. You can't do that. And is employed simply because the jury would find these beliefs morally reprehensible. Moreover, the state's use of harmful and divisive stereotypes, whether racial or religious, those are both protected classes, without any compelling justification, violates both due process and the Equal Protection Clause. Batson, see Batson versus Kentucky, JEB versus Alabama, Bush v. Vera, Cesares versus State, and some other things. Finally, Texas Rule of Evidence 404 and Article 38.37 of the Texas Code of Criminal Procedure both prohibit the use of unnoticed extraneous bad act evidence, and in this case, the state's offered evidence was unnoticed. See Exhibit 10, State's Notice of Extraneous Offenses. The state sought to inject these proceedings with allegations that Mr. Warden harbored animus toward individuals, specifically a black child, on account of race. Delicious, delicious caffeine. That allegation had absolutely zero. That allegation had nothing to do with the allegations made on the basis of the state's charged defense, nor any issues involved in the case. The state introduced this evidence for the purpose of attacking and penalizing Mr. Warden based on their false idea that Mr. Warden had a belief system that involved him not wanting to associate with Black individuals, protected conduct under the First Amendment to the United States Constitution. This assertion was highly damaging, inflammatory, calculated to be inflammatory, prejudicial, and Mr. Warden was harmed by the state's actions. If true. I mean, if it is true that the state did make these statements, then yeah, that would be inflammatory. And especially if 4 out of the 12 members of the jury were Black, that's inflammatory and that's prejudicial. And that would be wrong. And if you're so biased, if you're so jaded, if you're so tribal that you can't see that, then you have the problem, not me. Not only did the state present this allegation against Mr. Warden during the testimony of the complainant, the state emphasizes testimony in a direct, emphatic way in their closing statements, including by shouting and pointing at Mr. Warden during the relevant portions of the argument. It was yelling, it's shouting. I don't want to think the court would have allowed the DA to shout or yell. I'm going to assume that that is a little bit of dramatic hyperbole, and I'm going to assume that the district attorney or the ADA might have pointed and spoke loudly. I seriously doubt there was yelling. Felipe Hemming wears black orthopedic shoes with Velcro straps. Is that really the quality of the conversation we have going on in my chat? Okay, we're talking about shoes. All right. Is Merv wearing pants? Of course I'm not wearing pants. Don't be ridiculous. The state's case against Mr. Warden was weak, unsupported by any contemporaneous outcry or any physical evidence. You don't need physical evidence to get a conviction. I just want to point that out. A lot of people say there was no evidence. A witness's testimony is evidence. So the daughter, the complaining witness, the victim, saying that Earl engaged in inappropriate sexual contact with her, that is evidence. Now, they're distinguishing between that and physical evidence, i.e. they didn't find semen on her or bruises, pictures of a ruptured or broken hymen or whatever. That's what they're saying. Now, do they need that? No, the state does not need that. The state doesn't need a contemporaneous outcry, i.e. contemporaneous with the arrest. There was more than likely a contemporaneous outcry with the initial opening of the case. So there was an outcry that started the case rolling. The police didn't just decide to start investigating this in 1997 for no reason whatsoever. There was some report somewhere. The victim made statements. Back then, the victim made statements. At least that's my understanding of it. And if I'm wrong, I'm wrong. The allegation pitted the credibility of complainant, whose story changed not only prior to trial, but also during her testimony before the jury, versus the perceived credibility of Mr. Warden. Mr. Warden has no credibility. He is a congenital liar, but it's my understanding that he didn't testify. So it wouldn't be his perceived credibility. I would suppose it would be the credibility of the witnesses he put forward. And I believe he put two or three witnesses forward, maybe 3. The state maneuvered through this weakness by presenting that Mr. Warden was a racist towards Black individuals, an attempt to make him seem morally reprehensible, particularly when the dynamics of the accusation and audience are considered. The accusation coming from a Black prosecutor and to a jury that was comprised of several Black individuals. This type of attack is not only impermissible, but also completely demonizes an individual, especially when you might be tasked with considering that the claimed racial animus is targeted toward a group of which you are a member. We must not be blind to the fact that the harboring of racial animus towards others is seen as repugnant to our ideals as Americans in society. And the presentation of this evidence and the manner in which it was presented was only calculated at producing one result: make the jury find that Mr. Warden was a morally reprehensible person, so that they would find a way to believe the contradicted testimony of the complainant. Compounding this error, the state also presented that Mr. Warden was a Mormon, that he attempted to get the complainant to convert to Mormonism, and did so because it is acceptable in the Mormon church to marry one's own children. Not only were these allegations false, they also serve as nothing more than injection of religious stereotyping and animus that is repugnant to our First Amendment and the 14th Amendment's due process and equal protection clauses. An individual has a First Amendment right to free exercise of religion and to associate with members of a religion. Similarly, a person has a 14th Amendment right under both due process and equal protection to have a trial that is free from divisive and harmful stereotyping on the basis of religion. Presenting evidence that a person is a member of the Mormon church and that the church permits the marrying of one's own children runs directly afoul of Dawson and its progeny. The state's assertion was, again, nothing more than an attempt to use the stereotypes of the Mormon church to penalize Mr. Warden for his alleged abstract beliefs, and was, quote, employed simply, end quote, so, quote, jury would find these beliefs morally reprehensible. Now, I take a huge exception to the use of quotes when they're not attributed to something. So, who said that these are abstract beliefs? Who were you quoting? Who are you quoting about employed simply? And why did you need to quote employed simply? Like, obviously, that was stated in context of something longer, and that would have had to have been part of a much more complex sentence. So I don't know. I don't know why they chose to put the quotes in there. Um, and I don't like that. I don't like that particular maneuver. If you're going to quote something, you need to attribute those quotes. He might have been quoting from Dawson. I assume he was quoting from Dawson. If he was, he should have put the citation in there. Again, these assertions were damaging, inflammatory, calculated to be so, prejudicial, and Mr. Warden was harmed by the state's actions. Not only did the state present this allegation in the evidentiary phase of trial, but the state presented this testimony in a direct, emphatic way in their closing arguments. Man, they just keep hammering this home. I like shorter briefs. I like shorter motions. 30 pages seems excessive, but I guess you don't want to leave anything out when you're doing something this important. So, including shouting and pointing at Mr. Warden during the relevant portions of argument, focusing on a flagrant stereotype that he is a member of the Mormon Church, a religious group that permits marrying of one's own children. In light of the state's weak evidence of Mr. Warden's guilt, the state's appeals to racial animus and religious stereotyping prejudiced Mr. Warden, focusing the jury on how morally reprehensible his belief system must be, rather than focusing on the elements of the charged offense and the fact questions concerning those elements. Mr. Warden requests that this court finds Mr. Warden requests, words are hard. Mr. Warden requests that this court find the state's presented claims of racial animus and the state's presentation of religious stereotyping, all unnoticed extraneous bad acts, violated Mr. Warden's First Amendment rights to freedom of association and the free exercise of religion, and also violated his 14th Amendment rights to due process and equal protection under the law. Mr. Warden also requests that this court find the state's presented evidence also violated Rule 404 of the Texas Rules of Evidence and Article 38.37 of the Texas Code of Criminal Procedure. Mr. Warden moves this court, pursuant to Rule 21 of the Texas Rules of Appellate Procedure, to hold a hearing on this motion for new trial, allow the presentation of both affidavits and live testimony to support this presented claim, find Mr. Warden has established the error raised herein, make oral or written findings of fact, and enter a written order commanding that a new trial should and must be granted. Ill? Why are we doing L? That's weird. Is that a Texas thing? Ill, L, and the ill, and then is there going to be a ILL or I? Now it's to I. Okay. I was hoping it would be illin down at the bottom. All right. I think this is supposed to be Roman numeral too. The numerous outside influences on the jury violated Mr. Warden's right to a jury trial under the Sixth Amendment and his right to a fair and impartial jury under the Due Process Clause of the 14th Amendment, and a new trial should be granted. And don't get too hung up on the little typos and things like that. Typos are typos; they happen. I mean, you present enough, you prepare enough briefs, you're going to have typos, and it's always easier from someone to find the typos than for you to find them. One of the things that I do, or at least when I have all the time in the world to do, is I will read my motions, my pleadings out loud, and actually like say every word. And if I stumble, that means the court's going to probably stumble. And you tend to find errors like this if you actually read it out loud. It's when I don't read them out loud that I tend to have the real issues. So I don't hold any of this against the attorney. Mistakes happen like this. You just gotta roll with it. The court's not going to blink an eye at it. The court's just going to move on and try to find the meat of the argument. Mr. Warden should be granted a new trial in this action because numerous outside influences on the jury serving to establish juror misconduct violated his right to a fair and impartial jury free from outside influence under the 6th and 14th Amendments of the U.S. Constitution. The 6th Amendment of the U.S. Constitution provides that in all criminal prosecutions, the accused shall enjoy a right to an impartial jury. That's the 6th Amendment. In conjunction with the 14th Amendment's Due Process Clause, this right guarantees the individual a right to a fair and impartial jury that is free from outside influence. Shepard v. Maxwell. Texas laws will establish that outside influences must not be brought to bear on any juror. In order to be entitled to relief on the basis of outside influence or juror misconduct, the defense must establish that an outside influence was improperly brought to bear on any juror. I don't think they need to establish that much in order to get the hearing, the motion hearing. I think they just need to basically make a plausible allegation that, if true, an outside influence is something originating from a source outside the jury room and other than from the jurors themselves. Then, without delving into the jury's deliberations, and then a big four. What's the big four? Evidence of the jury's deliberations are not admissible under Texas Rules of Evidence 606B. Okay. Then, without delving into the jury's deliberations, the trial court must use an objective analysis to determine whether there is a reasonable probability that the outside influence had a prejudicial effect on the hypothetical average juror. And again, we're looking at a reasonable probability. That's pretty low. Numerous outside influences plagued Mr. Warden's trial. And yes, I like the use of the word plague because they were a plague. And were brought to bear on the jury, including an attendee perceived to be associated with Mr. Warden, following jurors to their cars, communications and attempts to communicate with jurors by attendees openly against Mr. Warden, attendees shouting that Mr. Warden was a rapist and sex offender within earshot of the jury, the trial court's mid-deliberation comments that they had heard about 25 years of this dysfunctional family in just 2 days, and the trial court's repeated emphasis that there was a lot of crazy stuff on the internet about Mr. Warden if the jurors were to Google him. These outside influences are impermissible and originating from outside the jury room and were not a result of the actions of the jurors themselves. An objective analysis of these events establishes a reasonable probability that these outside influences would have a prejudicial effect on the hypothetical average juror. Jurors being followed to their cars by a trial attendee walking behind them, amidst them, and carrying a camera and filming equipment raises serious concerns about safety, privacy, and security for any juror, particularly when the attendee has been perceived as being associated with Mr. Warden. Such concerns inevitably become aimed Mr. Warden's way, as the trial court itself made clear when it told Mr. Warden that, quote, his friends had not done him any favors, end quote. Mr. Warden ultimately became seen as being accountable for Mr. Gray's individual and unacceptable conduct. And I agree that Mr. Gray's conduct was unacceptable. And I also don't think that Earl should be penalized in a trial on a completely different topic for the actions of Mr. Gray. Attendees actively against Mr. Warden speaking to jurors outside the courthouse in a minute-long conversation that was more than just casual passing would also have a prejudicial effect on the average hypothetical jurors. These attendees were not there to help Mr. Warden receive a fair trial. Now, okay, one other thing, the Dougie thing. So the big defense that the PK support crew for Dougie were using was that Dougie was just talking about horses or some shit to the juror, right? But riddle me this. If you become friends with someone, assuming that Dougie has the capacity, the intellectual capacity to put down his crayons long enough to become friends with someone, if you build a rapport with someone, they're more likely to not want to do things to oppose you. They're going to be more likely to be agreeable with you. And by attempting to build a rapport with a juror, talking about horses or what have you, and then sitting on the anti-Earl side, it could be, again, it could be prejudicial. So just Dougie should never have talked to a juror, period. He should have sat in his corner, eating his crayons, and being a good boy. One attendee was ordered out of the courtroom after speaking to veneer panel members during voir dire, and the attendee was seen speaking to jurors, and the attendee seen speaking to jurors was also in the hallway outside the courtroom shouting that Mr. Warden was a rapist and sex offender within earshot of the jury, to such an extent that the bailiff came outside to address the issue. The court's commentary on evidence during deliberations about the jury having heard about 25 years of this dysfunctional family in 2 days of testimony would also have a prejudicial effect on the average hypothetical juror. Naturally, the court's role in our system of justice puts it at the center of the entire process. The jury and even the lawyers look to the court as the authority on everything that takes place inside the courtrooms. A trial court's mid-deliberation commentary that the jury saw 25 years of this dysfunctional family, particularly right before the jury went home for the day, makes any rational person wonder what caused all this dysfunction the court just mentioned. Sexual abuse? This commentary prejudicing Mr. Warden came from the most authoritative source in the entire process, the court. I don't like it. When in a pleading, the attorney asks hypothetical questions. The attorney should make assertions, in my opinion. This is just my opinion, and I'm only a first-year family law attorney. So, okay. I've heard that Dougie has been kicked out of PK, and, I did have a lot of members of PK coming in to defend Dougie, so I'm gonna stick with my rational inference from what happened when I called Dougie out about it the first time, that PK in fact does support him, or at least a few members of PK do, whatever. The court's repeated emphasis that there was this crazy stuff on the internet about Mr. Warden also served as an outside influence that would affect the average hypothetical juror. It is understood that the court has a responsibility and duty to ensure the jurors do not seek outside or consult outside information. But that responsibility and duty cannot extend to creating impressions about what would be found if they were to look, or present that information in such a way, or present that such information would be found in what would be an appealing way. Moreover, the follow-up events make it clear that the jurors were impacted by these issues. As an initial matter, at the end of the first day of trial, the jurors reported they were evenly split 6-6, and half the jurors indicated that additional deliberation time would do no good. The jurors then adjourned for the day, and then returned jurors reported to the court that they had been followed to their cars by the individual subsequently identified as Mr. Gray. Additionally, the jury's final note raising concerns about the audience members and the jurors' privacy concerns in light of audience members in light of the audience members shows that these jurors were actually impacted by these outside influences, the same as any hypothetical average juror would be. Mr. Warden requests that this court find that the outside influences constituting juror misconduct violated Mr. Warden's right to a fair and impartial jury-free trial from outside influence under the 6th and 14th Amendments to the U.S. Constitution. Mr. Warden moves this court pursuant to Rule 21 of the Texas Rules of Appellate Procedure to hold a hearing on this motion for new trial, allow the presentation of both affidavits and live testimony to support this presented claim, find that Mr. Warden has established the errors raised herein, make oral or written findings of fact, and enter a written order commanding that a new trial should and must be granted. Number 3, the state presented false and misleading evidence that Mr. Warden was racist and a Mormon, violating his right to due process of law under the 14th Amendment, and a new trial should be granted. Mr. Warden should be granted a new trial in this action because the state used and presented false and misleading evidence that he was both racist and a Mormon, and that it is acceptable in the Mormon church for one to marry their own daughter in order to obtain the conviction in this action, in violation of the due process clause of the 14th Amendment to the United States Constitution. Due process prohibits the state from securing a conviction through the use of false or highly misleading evidence. See Nipu versus Illinois, holding the conviction obtained through the use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. Okay, I see what they're saying. So they're saying that that the DA or the ADA knew that Earl was not a Mormon, and they knew that Mormons don't marry their own daughters. And because the DA, she used this evidence, knowing it was false, it's a violation of the 14th Amendment. I see what they're saying now. I think they should have presented it a little more clearly at the beginning, but it makes sense now. It makes sense why they're calling it false or highly misleading evidence. Okay. Under federal precedent, it is not necessary that the prosecution actually knew the testimony in this case was false. It is enough that the prosecution should have known it was false. Makes sense. Explaining that error occurs with the use of false evidence where the evidence demonstrates that the prosecution's case includes perjured testimony the prosecution knew or should have known of the perjury. And though the case law in this area frequently refers to perjured testimony, there is no requirement that the offending testimony be criminal perjurous. Rather, it is sufficient if the witness's testimony gives the trier of fact a false impression. These rules are not aimed at preventing the crime of perjury, which is punishable in its own right, but is designed to ensure the defendant is convicted and sentenced on truthful testimony. Under federal precedent, to constitute a violation of due process, the state must knowingly use false testimony. However, the Texas Court of Criminal Appeals allows applicants to prevail on due process claims when the state has unknowingly used false testimony. Maybe it wasn't going where I thought it was going. Okay. When reviewing due process violations, the Supreme Court has directed that due process protections extend to any information in possession of the entire prosecution team. Convictions based on false evidence must be reversed if the false evidence may have had an effect on the outcome of trial. This has historically been known as the materiality prong. I'm learning something new today, kids. They don't have this in family law. To obtain relief, Mr. Warden must show, number 1, that false evidence was presented at his trial, 2, that the prosecution or the prosecution team knew or should have known the evidence was false. This element is not required to be established under the Texas court's application of the standard. And 3, the false evidence may have had some effect on the outcome of the trial. No additional showing of harm is necessary. Interesting. Each factor is established. Mr. Warden is not racist. See Exhibits 1 and 4. Why? Just the fact that he has to prove he's not a racist. Like, I've never seen the guy say or do anything racist. So, like, all of a sudden he's a racist. Like, and now he has to prove he's not? Weird. Mr. Warden is not a Mormon, nor has he ever been a Mormon. Like, just him saying I'm not a Mormon should be enough. Like, I'm not a Mormon. That's it. Case closed. Never been a Mormon. Case closed. How do you prove what your beliefs are, other than by saying what your beliefs are? How do you prove it? Like, it's crazy. The state's presentation of this evidence was both patently false and misleading. Clearly false. Patently false. Clearly patently false. The false and misleading evidence also had an effect on the outcome of the trial. As discussed in Section 1 Supra and incorporated herein for purposes of brevity, the state's presentation of this false and misleading evidence was highly damaging, inflammatory, calculated to be inflammatory, prejudicial, and Mr. Warden was harmed by the state's actions. Not only did the state present this allegation against, or these allegations, plural, against Mr. Warden during the testimony of the complainant, the state emphasized this testimony in a direct, emphatic way in their closing arguments, including by shouting and pointing at Mr. Warden during the relevant portions of the argument. The state used this evidence to merely show that Mr. Warden was a morally reprehensible person, so they could find a way to believe the contradicted testimony of the complainant. Mr. Warden requested this court find that the false and misleading evidence violated Mr. Warden's right to due process under the 14th Amendment to the Constitution. Mr. Warden moves this court pursuant to Rule 21, blah, blah, blah. We've read that before. Section 4, Mr. Warden was deprived of his 6th Amendment right to the effective assistance of counsel, whereas trial counsel failed to object to the state's injection of unnoticed allegations of racism into the trial and the state's improper closing arguments that Mr. Warden was a racist and a Mormon. That's what you get when you hire the second best criminal defense attorney in Harris County. Never settle for second best. Always hire the best. Earl would like to show off his enormous war chest, quote, war chest, end quote. And he shouldn't have hung on to that war chest. He should have he should have spent that to get the best attorney in Harris County. Mr. Warden should be granted a new trial in this action because he was deprived of his 6th Amendment right to the effective assistance of counsel, where trial counsel failed to object to the state's injection of unnoticed and false allegations that Mr. Warden was racist and refused to let his wife stay in their home because she was pregnant with a black child, that Mr. Warden was a Mormon and was trying to get the complainant to convert to Mormonism so he could marry her. The 6th Amendment to the U.S. Constitution, made applicable to Texas through the 14th Amendment, provides that in all criminal prosecutions, the accused shall enjoy the assistance of counsel for his defense. The 6th Amendment provision provides more than just the presence of counsel alongside the accused, but rather provides for the right to the effective assistance of counsel, envisioning counsel playing a role that is critical to the ability of the adversarial system to produce just results. Strickland v. Washington. To prevail on a claim of ineffective assistance of counsel requiring reversal of a conviction, an applicant must establish by a preponderance of the evidence that 1, trial counsel's performance was deficient, 2, this deficient performance deprived applicant of a fair trial. Under the first prong of Strickland, the applicant must show that the trial counsel's performance fell below an objective standard of reasonableness. Stated differently, the applicant must show by a preponderance of evidence that trial counsel's actions did not meet the objective norms for professional conduct. Under the second prong of Strickland, the applicant must show that the deficient performance prejudiced the defense. Restated, this requires establishing there is a reasonable probability that but for the trial counsel's deficient performance, the outcome of the proceeding would have been different. A reasonable probability is that which is sufficient to undermine confidence in the outcome. Because if there is a reasonable doubt, he shouldn't have been convicted. In evaluating an ineffective assistance of counsel claim, the reviewing court must consider the totality of the evidence before the judge or jury. Deficient performance. As outlined in Section 1 Supra and incorporated herein for all purposes, evidence of unnoticed extraneous offense evidence of unnoticed extraneous offense evidence of alleged racial animus in religion was inadmissible. That was tortured. That was a tortured sentence. And trial counsel had a duty to keep the evidence out under the 1st and 14th Amendment of the United States Constitution, Rules 403 and 404 of the Texas Rules of Evidence, and Article 38.37 of the Texas Code of Criminal Procedure. Trial counsel recognizes that he failed to lodge any objection to the relevant testimony portions of the racial animus testimony, and trial counsel failed again to object when the state offered this testimony during closing arguments. Had counsel objected, the court would have been legally required to keep this evidence of racial animus out. This failure to object constituted deficient performance under the first prong of Strickland. Now, I have to give the second best attorney in Harris County some props. There is there is quite a possibility that by saying, yes, I failed as the attorney, he might open himself up for some sort of a malpractice lawsuit. He literally is saying, I deviated from the standard of care. So, mad props to that attorney for putting his hand up and say, I screwed the pooch. Additionally, there can be no reasonable or constitutional acceptable trial strategy for allowing such inadmissible evidence into trial. So basically, there's a lot of leeway for the attorney. Like, the attorney can choose how many witnesses to call, which witnesses to call, which witnesses not to call, what evidence to put forward, what evidence to not put forward. And it's like trying to get an ineffective assistance of counsel because the attorney didn't call a witness that the defendant thought they should call. I mean, that would fall under a trial strategy. Like, the attorney might have had a viable, a real strategic reason for not calling that particular witness. But failing to object to the racial and religious statements, that there's no strategy to that. He just screwed the pooch. In addition, though trial counsel properly objected to the religion evidence that Mr. Warden was a Mormon seeking to marry his own daughter, trial counsel failed to object when the state emphatically argued this testimony during closing statements. Prejudice. As discussed in Section 1 supra and incorporated herein for all purposes, Mr. Warden was significantly prejudiced by his trial counsel's failure to object, as trial counsel's affidavit makes clear. State's injection of unnoticed and false allegations that Mr. Warden was racist and refused to let his wife stay in their home because she was pregnant with a black child, and that Mr. Warden, why is black capitalized? That is so weird. And Mr. Warden was a Mormon and trying to get the complainant to convert to Mormonism so that he could marry her was highly damaging, inflammatory, and calculated to be inflammatory and prejudicial. Not only did the state present this allegation against Mr. Warden during the testimony portions of the trial, the state emphasized this testimony in a direct, emphatic way in their closing arguments, again by shouting at Mr. Warden, blah, blah, blah. Morally reprehensible, yada, 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 trial counsel's deficient performance, prejudice, Mr. Warden. Mr. Warden requests this court find he was deprived, yada, yada. Conclusion. Mr. Warden's conviction was a result of the state's injection of racial and religious animus into the trial, outside influences on the jury and juror misconduct, the state's use of false and misleading evidence, and the ineffective assistance of trial counsel. These errors can be cured only by the granting of a new trial, and the court has the authority and obligation to grant a new trial under such circumstances. Accordingly, he moves for a new trial. So, again, I am of the opinion that this trial should have come in or around 1997, probably before 2000. But Lord, the Mormon stuff and the racial stuff, they concern me. They concern me a lot. They concern me more than the because they'll be on the record. Those will be on the record. You'll be able to look at the actual transcript and see those. So those are very concerning. The jury the outside influences on the jury are also concerning to me. I strongly suspect, I would say there's probably, I would give it like a 95% chance that Earl's going to get an actual hearing on this. I would guess there is a greater than likely chance that Earl's going to get a new trial. And I hope and I pray that we can actually get a clean trial this time without people like Dougie and Teresa Richard and John Gray, extra good citizen, whatever the hell his name is, and all the other folks could just stay the fuck out of it and let the lawyers do their jobs, let the court do its job. There were 4 blacks on the jury. Just let them get it done. Uh, the big question seems to be, will Earl be released? So my understanding is, if the court grants a new trial, it resets everything back to how it was right before the first trial. So yes, is my understanding that Earl would be re-released back out onto his bond. What do you have, like a $50,000 bond or something like that? So that's my understanding of what would happen. So if there's any other questions, now would be your time to ask them. I'm going to take a sip of my Go juice. Felipe says no, he stays in a cage. It's not my understanding, but I could be wrong. I'm not an attorney licensed practice in Texas, and it's just my best understanding based on the case law. But Felipe says it with confidence, so he's probably right. Merb, this is Texas. It ain't going to happen. Lee Harvey Oswald has a better chance of a new trial than Earl. Well, I respect your legal chops, Jim O'Donnell, Esquire. Um, you know, I love the fact that I get to be educated by my much more intelligent, educated, um, certified audience. You guys give me continuing education every day. In fact, I turn in my comment section at the end of every year for continuing MCLE credits. Um, you guys have given me all 25 of my MCLE credits that I just turned in, by teaching me all the stuff about the law. Felipe also said Earl passed a deadline for appeal. This is not an appeal. This is a motion to the trial court. An appeal would be to the Court of Appeals. Uh, so, I don't. When I say that Felipe is an expert, I'm not saying he's an expert. I don't believe he's holding him out to be. I don't believe that Felipe is holding himself out to be a Texas attorney or an attorney at all. He just likes to say things with a lot of confidence, because why wouldn't you? Um, I agree, Gardner Earth guy. I I would like to see a closed court. Uh, you should. I live in Texas. You don't. Yeah, whatever, Jim. Like, uh, you can do law gooder than me. Yeah, absolutely. Uh, okay. Okay. All right. I think this is going to turn into Felipe bashing, and I'm not interested in that. So thank you for watching, and have a great day.